Thanks so much for taking some time out of your busy days to attend this presentation. Now, one of the recurring themes in this presentation is that financial advisors and lawyers complement each other in really profound ways, and the more we can work together as industries, the more likely we are to achieve outcomes that are good for our clients. Now, in terms of my background and how I've come to this perspective, I've been working at the intersection of the legal and financial services industries for almost my entire career. I have worked for a stint here as a private client lawyer and trust lawyer, and also worked in a professional trustee type capacity. But in Australia, I worked for a number of years as a financial services lawyer. This gave me a really terrific insight into how the two professions can work together and complement each other. Now, my experience in financial services law in Australia, plus my current interest in financial advice, probably lead me to need to address the elephant in the room, being the current Royal Commission in relation to financial services in Australia. I'll get that out of the way. I just want to say that this is terrific for financial advice and the financial services sector. Sunlight is one of the best forms of disinfectant. A lot of the more spectacular stories that you're hearing are, in some ways the result of systemic issues within certain organisations and types of organisations, but it is very much the case that you are hearing some of the worst stories, and there are in fact a number of excellent advisors both in Australia and New Zealand. If there's one lesson I think that consumers can probably take away from it already, is to really prioritise getting independent advice rather than advice that's affiliated with product issuers, just to ensure that you are actually receiving financial advice rather than advice masquerading as, or a sales spiels masquerading as advice. But I think despite the reputational damage it might be causing the industry at the moment, it's going to be a really fantastic outcome for high quality financial advice over the long run. Now, I guess one thing worth mentioning is that there are a number of different types of financial advisors. It's easy, like these penguins, to look at them and think that they're all kind of the same, but there are a number of different types of advisors. And so I'll get a few of the acronyms out of the way, and perhaps clear things up for those of you that haven't understood quite what the distinctions are. So the three main types of people who call themselves advisors fall into one of these three acronyms. There's QFEs, which stands for Qualifying Financial Entity Representative, RFAs, Registered Financial Advisors, and Authorised Financial Advisors. I'll get qualifying QFEs out of the way first. They are basically representatives of financial organisations that are effectively product issuers. They're probably not advisors in the way that I'm talking about advisors in the context of this presentation, so I'll just leave them to the side. RFAs and AFAs, there's only one letter different in the acronyms, but they are quite different in terms of the hurdles you need to pass in order to become one rather than the other. So to be a registered financial advisor is actually not that difficult. You need to fill in a few forms. You need to become a member of a dispute resolution scheme. You need to pay some fees, probably looking at around between $1,000 and $1,500. You need to have a satisfactory criminal history, and for good rather than bad. And basically you can be registered to be an RFA. To be an authorised financial advisor, you need to meet all of those hurdles. You do need to be registered, but you also do need to meet minimum educational requirements. Those educational requirements are not as high as those required to practice law, but they're not negligible. I would characterise them as probably more demanding and time intensive than doing profs, for instance. And I think it's a relatively good grounding for providing good quality advice. I'll be honest here. I mean, I don't think providing advice is as difficult as providing legal advice. And I do think a lot of advisors, I'm probably being a bit candid, but I think a lot of advisors do talk up their compliance obligations and burdens. Having come from practicing both law and financial advice, I actually don't think that the compliance obligations are that extensive. I think it's more just historically they haven't been used to it, and because of the institutional nature of some advisors, there are often additional policies and procedures and layers of bureaucracy that can make compliance seem even more burdensome. Sorry about that. That was a aside I wasn't meaning to go. But say an AFA needs some minimum educational requirements. They also have to adhere to a code of professional conduct. That means they need to provide, amongst other things, they need to meet CPD requirements, and they do have a primary requirement or obligation to put the interests of clients above their own. So AFAs, there are a number of hurdles. It's a lot harder to become an authorised financial advisor than a registered financial advisor. But what you actually find in practice is that they kind of complement each other, both because of the regulatory settings and a few other, historical accidents or what have you. What you'll tend to find is that authorised financial advisors, they can provide advice in relation to more complex investment products, and also provide investment planning services, which RFAs are unable to do. So what you'll find is most investment advisors are AFAs, whereas most advisors that specialise in insurance or lending will be RFAs. With insurance in particular, I really do think it's worth going to a specialist. So for the most part, you will find that if you're dealing with insurance, you'll be dealing with RFAs. Now, I want to step back a bit in terms of talking about financial advice. Actually, I'll just go back here very quickly. I just want to say that this distinction between RFAs and AFAs, that will be changing in the near-ish future. There is a bill in place that will actually repeal the Financial Advisors Act, which creates this distinction, and the bill will also add a number of provisions to the Financial Markets Conduct Act, which will in the future regulate financial advice. This distinction's been around for quite some time, and it will be around for a while, so I still think it's worth a distinction that's worth making, and there will be analogues in the new legislation, even if it might not be quite as easy to identify. Now, financial advice, it's easy to think of it in terms of, especially when you're talking about investment advice, trying to maximize returns and focusing on helping clients achieve their lifestyle outcomes. And to a large degree, it is about that. However, I would actually step back further and say that the first thing that financial advisors are about is really protecting clients, helping clients manage the risks to which they're exposed. And in that sense, I think that if you really step back, financial advisors and lawyers are really doing very similar things for their clients. Obviously, you bring technical skills and expertise and knowledge to the table, but if we really step back, providing good quality legal advice is to a large degree about helping clients to manage their risks. Financial advisors do the same thing. We just bring a slightly different perspective and set of skills and knowledge to the table when doing so. So one of the things I'm hoping that you come away from this presentation with is a little bit more confidence about when you can and can't, and perhaps even should be providing financial advice, and to what extent to clients. So I'm just going to talk very briefly about what constitutes financial advice. As I mentioned, advice is currently defined and regulated primarily by the Financial Advisors Act. And financial advice is actually part of a broader term, which is financial advisor service. So there are 3 prongs to that, and it includes financial advice, which means recommendations in relation to financial products, usually as to whether to buy or sell those financial products. There's investment planning services, which is what AFAs can do, and that's basically preparing a plan for clients based on their circumstances, needs, and objectives to try to help them achieve those objectives. Then there's also a discretionary investment management service, which I won't really go into here. It's basically where an advisor has been given the authority within certain guidelines to make decisions on behalf of clients without seeking their explicit instructions for every single transaction they enter into. So that's pretty much regulated fairly heavily in its own right, but is probably in some ways, I would say, secondary to the initial advice or investment planning service that's already been provided. So can lawyers provide financial advice in a financial advisor service? The answer to that is an emphatic yes. Section 14, subsection 1, paragraph D of the Financial Advisors Act specifically says that a lawyer, incorporated law firm, or conveyancing practitioner providing a service in their ordinary course of business isn't providing a financial advisor service for the purposes of the Act. So basically, if it's in the ordinary course of your business, the Act doesn't apply. From that question, you can say, should lawyers provide financial advisor services? And I would say yes, and I'll give some examples very shortly. And if it's in the course of ordinary business, and if it's really about helping clients identify and manage risks, I think it's really appropriate to provide financial advice without going too far in terms of broadening the scope beyond what your particular level of expertise is. So I'll give an example. This one doesn't relate to older clients, although I will extend it to that. But the easiest example is where you might be preparing an estate plan or wills for younger clients who have young children. So let's say you're talking to mum and dad, they've got children who have just started school. You can prepare the best will that's ever been written, and they still may well not achieve their testamentary objectives if one of them were to pass away. The reason for that is most young parents are still in the early stages of the process of building wealth. So if one of them were to pass away, they probably won't have a huge amount to leave to the survivor. As a result of that, it is a time of life where it's particularly important to have life insurance so that if one of them were to pass away, the children wouldn't lose the survivor to grief as well as financial hardship. In that sort of situation, it's really valuable to point out the importance of life insurance in the context of their estate plan. Talking with older clients, one thing that strikes me is I regularly speak with people who are in their late 50s or early 60s whose children are financially independent. They've built up a nice little nest egg, and they'll still have really substantial life insurance policies where they're paying, especially at that age, really substantial premiums. I've got one client at the moment who's paying about $6,000 per year as an individual for life insurance. The reality is they don't need it. You're not really, if you're in a situation like that, you're probably not insuring for downside risk. The most you can really say is that you're insuring for perhaps a potential upside. It's almost like buying a lottery ticket for your spouse. So that's something I wouldn't necessarily tell a client that they don't need it, but it might be something you can raise for them to consider. They may be paying thousands of dollars of premiums for insurance they don't actually need. on that point, it's probably just worth mentioning from a practical point of view that a lot of people think of insurance in binary terms. So people often think that they either have or need insurance or they don't. A lot of people who have had a significant amount of insurance for a long period of time are reluctant to get rid of it. And it's almost that Murphy's Law where they feel that if they were to cancel it, they'd probably pass away the next day, and the other one would regret that for the rest of their life. There is always the option of actually just reducing cover and reducing the premiums, so that's often a more palatable approach to clients in that sort of situation. There are other times when lawyers are really valuable at providing advice. Let's be honest, you're often one of the lines of defense for clients. There are some times when you can be quite explicit about telling a client not to do something. An example where you might be providing advice in relation to a trust, or you may even be a co-trustee in some capacity or another. And what they're currently invested in, or what they're proposing that they invest the trust assets in, may be contrary to the terms of the trust. That's an easy situation where you can quite clearly say that you recommend against doing that because it's quite clearly against the terms that they can do. But more broadly than that, if you come across a portfolio and you notice characteristics that are potentially concerning or raise red flags for you, I think it really is appropriate for you to raise that with clients and maybe not make specific recommendations, but actually point out that they really should consider what they're doing and perhaps receive advice in relation to that plan of attack. An example might be with a trust where you have multiple beneficiaries and, say, capital and income beneficiaries, and an investment approach seems to be quite clearly favouring one type of beneficiary over the other, say generating a lot of income and not looking for any capital growth or potentially even risking the capital in order to generate that sort of income. That's a situation where, again, you don't need to provide explicit recommendations in terms of what they should do, but recommendations that what they're doing may be contrary to the terms of the trust and might make them vulnerable to any claims from other beneficiaries down the track. In light of that, I'll just give a few things to keep an eye on in relation to where there may be some issues or red flags. So a few things to look at are the level of diversification within an investment portfolio. So if you've got a client who has pretty much all of their investments or assets in one particular type of product or type of investment, it's quite possible they've got all of their eggs in one basket. Now, all else being equal, a good investment plan involves diversification, and that is to manage the risk of something going wrong with that one particular investment or small range of investments. Another one is liquidity. Liquidity refers to the ability to transfer an investment into cash within a reasonable period of time and without incurring unreasonable costs and uncertainty. Now, liquidity, the need for that can vary from client to client. Liquidity may not be an issue for a particular client. They may not need any cash flow or have any anticipated needs. Having said that, some clients do have very explicit needs, and they should be considered in relation to the portfolio. With some clients as well, not having access to funds can make them vulnerable to things going wrong or unexpected things in life where they might need cash. Another thing to look at is for the third parties involved with an investment, the custodians or trustees or counterparties. So, for example, a lot of the managed investment schemes that I really like, they use independent trustees or custodians for the investment assets. And what that means is that the investment manager might promote the product and might have control over how the underlying investments within the fund are made. The money is actually held by a separate third party, which makes it very hard for that money to be walked off with. The majority of the funds that I recommend use the public trust as their custodian and trustee. Another thing to look for is gearing. Gearing can magnify the returns, but it can also magnify the risks in relation to an investment. Now, sometimes this can be appropriate for a number of reasons, but gearing really needs to be considered in light of the client's risk profile, which can come down to a number of factors: the risk they need to take on, the risk that they're able to come back from any downturn or volatility, and also their psychological tolerance for their investments going up and down. Final one I'd look for, and this is especially with older clients, is complexity, especially as people get older and potentially more vulnerable and less inclined to follow their investments. I would say that an overly complex investment or set of investments is potentially a red flag that what is happening isn't ideal for that client. But again, these are just red flags or areas to think about when just having a preliminary look at a portfolio. It's a messy slide, this one, so apologies for that. Basically, here are a few scenarios where financial advisors could and potentially should be referring clients to lawyers, and also some where lawyers might want to refer to financial advisors. Now, one point I didn't bring up when I talked about RFAs and AFAs earlier in this presentation is the way that they're remunerated. Now, RFAs, which are normally involved with, say, insurance, they're remunerated by commission. But AFAs, or usually the investment advisors, as a general rule, on one of the few exceptions, will charge as a percentage of funds under advice. So that means if a client has an investment portfolio that they manage, they will tend to charge a percentage, usually roughly around 1% of that investment portfolio to manage and advise in relation to that. Now, that's different to hourly fees. And you'd know yourselves as lawyers, clients will tend to only engage a lawyer when they really think that they need to. Sometimes that's too late. Most investment-based advisors, they have a business model where it's not hourly rate, and it's actually in their best interest to engage with clients on a fairly regular basis. What this means is that they're in a really privileged position to see clients as their circumstances change and even be part of some of the big decisions that they make. So they're almost a canary in the coal mine in some situations, and they're in a really good place to identify when a client might actually want to seek legal advice. So a few examples are where a client's considering advancing a significant amounts of money to a loved one, for example, to help one of their children for a deposit for a home. Another one is when clients or somebody from their broader family are going through significant relationship changes, whether that is a separation or whether it's a marriage or they're getting close to slipping into a de facto relationship. Advisors will tend to discuss wills and EPAs and identify areas that require attention. I constantly have this conversation with advisors that they often ask clients, when did you last get your wills prepared? Whereas that's kind of the wrong question. The question really should be is, do you know what your wills say, and do they reflect your current testamentary wishes? Because circumstances can change pretty quickly about that. And another aspect of them having this privileged position is that they can actually notice and calibrate to a client, and when they're potentially becoming more vulnerable or less interested or less capable of keeping up with what's happening in their financial world. And again, this is a situation where they can really point out the benefits and virtues of getting legal advice and getting your affairs sorted out as soon as possible. On the flip side, there are circumstances where it's really relevant for lawyers to consider referring clients to financial advisors, whether that's to specific financial advisors or just saying, we recommend you seek financial advice, whatever works for you. Some in relation to insurance, I think it's really valuable to get an insurance advisor, even if they are remunerated by commission, who's experienced and will go into bat for them when it's time to make a claim. And they will be able to tell you what level of cover, what types of cover, who the best insurer might be for them, especially in light of things like their underwriting issues and their pre-existing health, any illnesses or anything that they've got. Another one is lump sums, clients coming into money, whether that's through selling a property, coming into an inheritance, selling an interest in a business. Having a third party to just bounce ideas off can be really valuable. And another one is actually modelling the decisions of some of the higher impact decisions that they're making, which I'll come to later in this presentation. Now, within the context of providing financial advice to older clients, one big chestnut or lens through which a lot of these lot of advice needs to be seen is how much do people actually need to sustain their lifestyle in retirement? Now, every 6 months or 12 months or so, you'll read an article about research from Massey University saying how much you need to retire with in order to have a choices lifestyle in a metro or rural environment. I guess it's useful, and at least it starts conversation, but I mean, I think it's pretty arbitrary to say that you need this particular figure. That's kind of like saying that a household with 3 children between the ages of 5 and 15 needs to have a household income of $120,000 to have a choice lifestyle, because everyone's different. What sort of lifestyle that you or any particular client wants is going to be profoundly relate to the lifestyle that they want, as well as other factors like the level of comfort or buffer they have, the level of certainty that they'll be able to sustain that lifestyle, any sorts of desires they might have in relation to leaving an inheritance for their children, can also come down to their feeling of what their longevity will be, and that might be a factor in terms of their existing health situation or their perception of how long they think they'll live for. And there are a huge amount of uncertainties in relation to retirement. I do forecasts for my clients, but I refer to them as floorcasts because there are just so many assumptions, and it's very difficult to predict the future precisely. There are methodologies that you can use, but you always have to use them with the understanding that that the future is inherently uncertain. For example, you don't know how long you're going to live. You don't know what your health issues are going to be. You genuinely don't know what investment returns you're going to be. And if anyone tells you they're lying, you also don't know what the regulatory risks are going to be. What's your entitlement to New Zealand Super going to be? What is New Zealand Super going to be paying? What will your entitlement be to residential care subsidies? The list goes on. The other factor is, the world's changed a lot in the last 10, 20, 30, 40 years. What other social, technological, economic, environmental, political changes are going to occur in the next 10, 20, 30, 40, 50 years? That's a context in which you need to plan, and I guess it comes down to that truism that the value of a plan isn't actually the plan, it's the planning that's involved. Another aspect of considering retirement is that it involves quite a different mindset to when you're working. So when you're working, you've got an accumulation model. So you're working, you've got an income, you're accumulating wealth so that you will have a nest egg when you retire. When you retire, however, you don't have an income coming in, and you're going to be spending certainly the income generated by that nest egg, but for the most part, you'll also be spending some of the capital or drawing down of that from that over the course of your retirement. Just to give you an example of that, so I mean, unless you're Bill Gates or one of his 0.1% peers, where you might be able to live off the interest or the interest of the interest, consider this really simplistic example with a huge amount of assumptions that show why people will often accumulate over time. So here we've got a couple with a nest egg of $1 million, also a mortgage-free home, and their intention is to live off passive income. So they're in a position that's it's enviable compared to most Kiwis. Whether it's enviable for you or not, that's your personal decision. Let's say, again, wild assumption that they can generate 3% inflation adjusted after tax every year, and that comes to $30,000 per year. Let's say they also receive New Zealand Super, $32,000 a year, which comes to $62,000 a year, or about $1,200 a week. That's terrific. And let's say at the end of, say, 30 years or so, they'll still have a really significant lump sum. If they pass away at any time between now and pretty much infinity, the other thing is that it kind of guarantees that their children will have pretty good inheritance, and they'll be flying first class on the many international holidays that they choose to take on that inheritance. Some clients and many people end up choosing to draw down on the capital. Let's say the exact same scenario as before, but here they're drawing down $10,000 per year. This means that they're now spending $72,000 a year rather than $62,000, or $1,400 a week. That's an extra $200 a week that will now enable them to enjoy life, or the same as previously, but $10,000 for a fairly nice holiday every year throughout their retirement. As you can see, the capital balance of their nest egg reduces gradually over time. So it's probably about half what it was at the start of their retirement 30 years in. Some clients might want to get more aggressive and draw down, say, $20,000 per year, so have $82,000 a year expenditure rather than, say, $72,000 or $62,000. Now, this might seem a bit more aggressive, but it does result in an extra $400 a week to enjoy life while they're still living. That does provide quite a bit of additional spending they can do. It's going to nicer restaurants, buying nicer wine, going on more trips throughout New Zealand or elsewhere. And that's a decision that some people might choose to make. And it really comes down to their tolerance for or what degree of comfort they want to have when they retire. Now, one assumption I made here is that, for example, that expenditure stays constant throughout retirement. The reality is that retirement expenditure tends to be U-shaped. Most people spend far more in retirement in the early years, where they've still, they're almost making the most of their newfound freedom. They've still got their health and their energy, and they want to make the most of those years. Over time, people become far less inclined to spend money or end up in situations that will cost them money until perhaps they start having really substantial health issues. So again, this is a simplistic approach with a number of assumptions, but it just it's kind of the lie that tells the truth. And I mean, even in this situation where the clients have been quite aggressive, let's say they retired at 65, so they're now in their mid-90s, they probably don't need $1,600 a week, especially if they've got their home. But if they do, they've got another option. They've still got the equity in the home, and so they can do a number of things. They could downsize or right size, might be the case at the time, or they can consider options like reverse mortgages. And I think that this decumulation model is one way of kind of putting reverse mortgages into context. They're not popular, and I mean, I can definitely see why. I mean, it's a perfect example where the magic of compound interest is actually working against you rather than for you. But I mean, let's say you're in a scenario where you're asset rich but cash poor, but you're living in the house that you want to live in for the next 4 or 5 years, and might even be that your partner's a bit vulnerable because they've got early dementia, and you know that as soon as they change into a different environment, they'll deteriorate very quickly. If that's the case and you've got a lot of equity in a property, it might be rational to draw down a little bit against the equity in your property, knowing that you might sell it in 4 or 5 years and you'll still have a substantial amount of equity even after repaying the reverse mortgage. Now, there aren't a lot of providers of these, and like I mentioned, they're not particularly common. Most providers will require that anyone who does get a reverse mortgage receives legal advice and usually financial advice as well. And usually there are really some fairly significant restrictions to what can be done. For example, it's usually can borrow 15 to 40% of the market value of the property, and there are even restrictions about what you can and can't do with the property, like in terms of major renovations. You need to maintain it, probably need to live there. You may not be able to rent it out or anything of that nature. My understanding is that New Zealand Law Society, at least in the recent past, had a set of guidelines for lawyers in relation to providing advice about reverse mortgages. And I guess one important thing that is worth considering is that if a family member is considering a reverse mortgage, it is often wise or prudent for them to mention it to other family members, especially if they've got children. Because it's quite often the case that there might be more desirable ways of funding things for the short term. So, for example, with a loan from one or more of the children that are secured against the property, it can be a win-win for everyone involved. Now, people are generous, and when they're heading towards retirement or in retirement, sometimes they want to do generous things, like lend money or give money to children to help them get onto the property ladder. Sometimes they want to do things for themselves, like buy a yacht or that fancy car or RV, and that's absolutely fine. And I admire those people who are in the position and that's within their values and priorities, and they want to do that. What is often the case is that they haven't given a huge amount of thought in terms of the implications and what it actually means to make that gift. And this is sometimes where a financial advisor can come in as well. So just to give you an example, I've got 2 scenarios that are otherwise identical except for one variable. We've got here a couple who are age 55 currently. They're looking at accumulating assets until they retire at age 65. And at that point, they're wanting to decumulate their capital with a plan that they'll decumulate in a way so that they'll have funds until they turn 100. Let's say they're considering to give $100,000 to one of their children when they're around age 59. What you'll see is that one decision will mean that instead of their capital decumulating at 100, it'll decumulate almost 6 or 7 years earlier. So that's quite a significant impact of that decision. I ran the figures for this particular scenario, and basically if they wanted to just reduce their expenditure in retirement so that they could keep capital until 100, they'd basically be reducing their expenditure by $200 per week throughout their entire retirement. I mean, in a situation like this, the clients probably can well afford to do it, and they probably get they may well get that value out of actually doing so. But the value of going through an exercise like this is that they can actually see with clear eyes, and that they can make this option, this decision, informed of the actual long-term implications of what that will be. Because, I mean, this scenario here, we're just looking at one payment of $100,000. If they have multiple children, for example, that might create a precedent or an expectation that other children might get that same payment in the future, which, again, if they model it, the implications will become more and more significant over time. The final thing that I'll just mention is that there can be situations where there are beneficiaries, where a client might have settled or have an interest in a trust that has different types of beneficiaries. I guess a perfect example are either testamentary or inter vivos trusts that have income beneficiaries and capital beneficiaries. And they might well have very conflicting interests. What I've seen, both from a legal perspective and also from an advice side, is that the issues that actually tend to come up in this sort of situation are less about actually managing it and more about identifying these issues in the first place and taking steps to manage it. Because there aren't any fast or easy answers to this sort of situation. It varies very much on the facts. So, for example, it would be determined how to treat the different types of beneficiaries will come down to the terms of the trust deed and the wishes and intentions of the settlors, potentially as set out in the letter of wishes. It might be impacted by the circumstances of the beneficiaries as well. What can be quite effective, especially when there is potential for this being contentious, is to have beneficiaries meet, and I've seen instances where financial advisors and lawyers and all of the beneficiaries meet together to have a fairly robust conversation, acknowledging these conflicts and developing an investment portfolio that works for everybody to the largest extent possible. So no easy answers there, but what's really important is that both the lawyer and any other professional, including a financial advisor involved, is well aware of the interests of everybody and prepares a plan that entertains all of them. So there you have it. I mean, I really hope that recurring message that financial advisors and lawyers, in large part, are playing the same game. We're helping clients achieve their goals, but perhaps even more importantly than that, we're helping them manage the risks to which they're exposed. We're just coming at it from slightly different angles, with different perspectives, and with different skills sets and knowledge. There's a large degree to which we complement each other, and I would encourage you to continue to build the relationships you have with the existing advisors that you come across. The reality is that some you'll just get on with a lot more, and what you'll find is they're usually very open to having a coffee or going that extra step, especially for their clients. Like I mentioned, they're not remunerated on an hourly basis. So any kind of reason to be high touch and to demonstrate value to their clients, they're usually very happy to go ahead with. What I want to see is better dialogue between the professions, between financial advisors and lawyers, both ways, and I think that over the long run, we're going to see much better client outcomes if we do that.